You have the right to remain silent.
Anything you say can and will be used
against you in a court of law. You have the right to an attorney.
If you cannot afford an attorney, one will be appointed for you. Why did you stop?
I'm done. You win.
Now, Hollywood does a real disservice to American citizens when they depict Miranda rights being violated on television or in the movies. Law and Order often has a scene where the defense attorney will go into the judge's chambers with the prosecutor, and the prosecutor will lament about something the defense attorney brings up where Miranda wasn't read, and suddenly the judge says, evidence is suppressed or the case is dismissed. Wrong! That is not what happened. Miranda rights come from a case called Miranda versus Arizona. And every school child in the country can probably recite the very famous Miranda warning about having the right to remain silent and this right to an attorney. They are two separate rights. But the remedy for a Miranda violation is simply a suppression of the statements that were made. So, if a client, a defendant, is in custody and the police are trying to elicit a statement from him, usually the test is referred to as custody plus interrogation. I'll talk about interrogation more in a second. But if there's some sort of violation of that, the only remedy for a Miranda violation is a suppression of the statements. Say that the officers are interrogating a murder suspect and they say to the murder suspect, hey, there's a guy in the next room that says, you're the one that shot him, and they didn't read him Miranda. Just because it isn't a question doesn't mean that there's some way to bypass those Miranda rights. Anything the officers are doing or saying in an attempt to elicit a response from a defendant requires Miranda if the defendant is in custody. Usually the law defines custody as when a reasonable person would determine they are not free to leave. Again, they don't have to be at a police station in an interrogation room behind a two-way mirror with Sipowicz and the gang watching with two-day-old coffee. They can be by the side of the road. They can be in the back of a squad car. If a reasonable person would not feel that they were free to leave, that is the definition of custody in Arizona and elsewhere. So there we are back with our guy. He's been told that the other person said that he's the one that shot him. He responds vehemently, I didn't shoot him. I just took the gun and I threw it over in that trash can. Now, the statement about him taking the gun and throwing it in the trash can, that's out. It can't be used. But the gun can. So any derivative evidence that's obtained based on those statements, that is still admissible.